And
It's
we're
going.
live.
Oh, all right. Super. Hey, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for May 26th of 2025. Brad, go ahead.
Well, Memorial Day first, obviously. Curt and I would like to thank everybody who's, I'm not sure. Everyone
Well,
confuses Veterans Day and Memorial Day.
it's
That's the
it's for
problem.
those
And
who
they've
served
all,
and were killed,
right. And
or
I,
I think it extends also to those who served and suffered grievous injury as well. So.
Sure, sure. So a good Memorial Day, and hopefully everybody remembers why we have the time off. Okay, so we're going to start. Oh, this one's mine. We're going to start, and I promise everybody, this is probably one of my last lawsuits that we're expecting decisions on. But it's not that I have that many. I just had so many in like a 2-month period. But we're going to start in Oswego County, New York, where residents petitioned under it's a old law. It's not that new, to dissolve the fire district. We covered this story originally when the same residents tried to tell the court, well, they've been violating a bunch of laws. They adopted too big of a budget, which is what spurred all of this. They adopted a significant increase in their budget, and some residents got upset, not understanding they were probably like $80,000 before that for a total budget. Insurance alone costs probably 30, 35, and you
And
can't.
a new pump is over $1 million now. So come on.
Yeah, yeah, and so I mean, people just don't understand. A foot of rope tripled in price, turnout gear tripled in price. In any event, they lost that lawsuit, and I was the attorney for that. But then they refiled a petition with allegedly 140 some odd signatures. They needed 80 or 90 or so. But when we saw the petition, it was just so riddled with things that popped out on us. But it's funny, so I'll get into the short of it, but the funny thing is the lawyer does a news quote, and lawyers, if you're watching, don't do this. He gets up and says, I represent the petitioners, and this is a slam dunk. There's no way that we are not getting this dissolved. And those are his words, slam dunk. You shouldn't do that. So don't get cocky until you've won.
Well,
But
I
anyway, they
gotta,
tried to petition. We found a whole bunch of problems with the petition itself. And the judge dismissed it for so many reasons.
yeah, and I covered some of them, and some of them are really they're not of interest to firefighters and all that. But I think what is interesting is, number one, there's a procedure to dissolve a fire district that doesn't involve the voluntary, like the fire department doesn't have to be the one to dissolve it, that the
Right.
citizens can dissolve it. Now, that's a New York law, but here's the other thing. Then what?
Yeah. So, there's a backstory to
Congratulations,
everything.
you won. Now there
Yeah.
is no fire department. So now what?
So it would go back. Well, so the fire district would be obligated under the law if they succeeded to come up with a plan of dissolution. And that the funny thing is, but the district has no authority. This is the problem with the law. The district has no authority to carry out the plan. They're dissolved. So only a town can solve it. And the town would have had to come up with a plan, which could be a different type of government entity of some sort. But there's only two options available. Well, maybe three. And here's part of the backstory. It was allegedly the neighboring fire chief who's one of the people who's trying to get this dissolved so
Oh,
they could take over the area. The backstory
interesting.
is very interesting.
Okay, interesting. So, um, you know, a little bit of a student of some parts of this, and looking at state law and also municipal charters, not all states require all municipalities to have a fire department, just like many municipalities don't have a police department. But
Right.
and often fire departments predate the establishment of the municipality. So you have
Yeah.
this fire department that was there before there even was a city or town. And so the city charter is written in a way that it assumes that you have this other entity providing fire service. And so now you dissolve that entity and nobody's got responsibility for firefighting. And then what?
Right. And here there's and by the way, the same law has been used to dissolve in New York many villages. So there,
Really?
same issue.
I'd
You
like to
got a
see
village
that.
that
I'd
comes
like
up
to
with a
see that
plan.
sometimes. And
And look, New York State dissolved the birthplace of women's voting. I mean, yeah. I mean, they incredible. Susan B. Anthony. I mean, they abolished or dissolved the village that is the birthplace for that. So, right in upstate New York. In any event, so what happens is the town's got to come up with a plan, right? It's a legal plan that exists.
But if by law the town doesn't have responsibility for it, how can they, that would be ultra virus, right? It's beyond what their legal authority is to do.
Yeah, so it's weird because in New York, a municipality other than maybe a city has no obligation to provide fire protection. So a town doesn't have to. I will note there's been only one other case on this law in New York State. It's also mine. It went to the state's highest court. That was the one time I got to appear in front of the state's highest court, the Court of Appeals. And that was a town who had a fire protection district. The voters voted to dissolve it. So we thought we won. There, we petitioned to dissolve a similar entity. And what does the town do? They split it in half and said, okay, instead of one, we have two. And it was a split decision at the court, but I lost. And I'm like, come on, that's ridiculous. But so the point is, the town can even do something ridiculous. But anyway, it failed this time. This is the second time they failed. Let's hope there's no third time they understand it. Okay, let's go to, so we have a theory or a theme. You don't say it that way, but you actually have a theme with all or maybe all the cases. They're all decisions, except one's a lawsuit where the municipality has won. So today's theme is it's good to be the king, I guess. So we're going to go to Washington, where their Court of Appeals affirmed, so the trial court decided and they agreed, dismissing a disability discrimination lawsuit. It was brought by a mechanic. Now, this is really interesting because of the failures and what the court found. So, and we're going to see this theme repeated today. So the mechanic claimed that that he was the subject of mean comments and harassing comments and workplace hostility that resulted in him having high blood pressure. I will say, when I read this, first I was like, oh, no way, you're going to win. It should be affirmed. And then I started reading the allegations, and I'm kind of like, maybe this should have been. But anyway, but let me go into it so people understand. So he started working in 2013. He was a mechanic. He claimed he had ongoing conflicts with coworkers, and as a result, his disability, which I guess is high blood pressure or so, but it got exacerbated by all the harassment. He had an accommodation meeting, and remember, you and I have said this, but if you do not have a accommodation meeting, informal meeting with your employer or with your employee who claims a disability, you're going to lose. You got to have this informal meeting. They have it.
Let's point that out. Even if the person does not have a disability, if they're claiming to have a disability, you have to have that meeting, even if it turns out they don't have a disability.
As it did here, because the court holds that this actually is not a disability. I was shocked at that. That's the part I was surprised at, but we'll get to that. So, right. So they have the meeting, and the court holds that he doesn't participate well enough, right? For its layman's terms. And he was, all the things he was claiming about, you didn't give me parts and supplies, and, you're picking on me and things like that. And I'm not being degrading to him if you're watching, but I get it. He claims he's subject to harassment, and results in him being stressed such that his blood pressure goes up. He requested a reassignment to a safe and healthy work environment as an accommodation. I think that was reasonable. To me, well, that was a reasonable request.
I don't know if you had the chance to read the complaint. I mean, I can only put so much in the article, but in the complaint, they referenced testimony by a union rep that he made a comment that he didn't want to take the accommodation. He didn't want to take the transfer because it would have interfered with his lawsuit.
Oh, well, the court notes him not wanting to cooperate, though not the reasons therefore. But,
right.
So that's interesting. So in any event, what they point out here, normally you and I, the cases we're reviewing, the employer didn't participate in the accommodation process. Here, it's the employee who didn't accommodate, which is a great holding for lawyers, if you do any ADA and make sure you document, we offered this. He wasn't cooperating at all, right? I mean, and the employee's got to try what the employer's offering. To me, that's how I read the cases, right? If it fails, you try something else until there's nothing reasonable left. In any event, and with the dismissal of the hostile work environment claim, the court says, while personally distressing, right, these are just isolated incidents and weren't tied to his disability.
Mhm.
That's true, I guess, but it still shocks me as the wrong holding. If somebody's
Well,
harassing you and it results in, right, it triggers a
well,
disability.
there's one more step though that I think was the linchpin here. He was harassed, okay? Just because a colleague harasses you does not make the employer liable.
Nor does it
It,
mean
and
he's being harassed because of a disability.
it has to be tagged on to the employer.
Right.
And when there's isolated incidents, and we don't know all the details, whether or not the employer did respond to each of the allegations and took measures and took reasonable measures and all that. But again, I think very often firefighters get the idea that if I'm being harassed, the city is liable, and that's not the case.
Right.
That's not the case. That if colleagues are harassed, now certainly if a boss is harassing you, that's
Oh, of
one thing.
course. Right.
But if a colleague is harassing you, the employer has to know about it, and the employer must have failed to take reasonable steps to address it. And I think that's another, it wasn't fully explained in what I quoted here, but I think that was also playing a role in the background.
And what I don't like about the court's holding is the reference to periods of harassment as isolated incidents. Because if it's a group concerted activity that has a number of different incidents, albeit they're single incidents and isolated, it doesn't mean that it's not a pattern. Now, here the judge says maybe so, but there's no proof that it was related to his disability. They weren't, right? And it would be different if they were picking on him for his disability. They weren't. They were just picking on him. So general harassment not related to the disability. And that is the right holding. I don't know.
As I was writing it, there's a little bit of a confusion here because he's on the one hand saying the harassment led to his disability, but then he's also saying, but I have a disability. And so,
which is exacerbated by the harassment.
Right, but the harassment is what causes the disability. So I think there's almost more, and you get into drafting complaints here, but there's almost a workers' comp component here where if the workplace caused your disability, that's
Can't
a
sue the employer.
and that also, and I can understand why the attorney didn't allege that because you got workers' comp exclusivity. But again, it's a difficult needle he was trying to thread, and the court wasn't buying it.
Yeah, and I don't think it's bad lawyering in this case. I think it's
Right.
bad. The facts were what they are,
Mhm.
right? And you got to time to the law, and he couldn't. I mean, that's just how it works.
Good thing about mechanics. Good thing about mechanics, unlike firefighters, is it's pretty easy for a mechanic to find another job.
Yeah.
A comparable position because they're in demand. Whereas with firefighters, it's a little bit more difficult. If you're 35, 40 years old and you leave one department, it's kind of hard to go find another job as a firefighter. Now, certainly as you progress up, there may be some positions, but
no doubt. Okay, let's go to California, Manhattan Beach, California. Another win for a city, a municipality here on our theme, where we have a federal judge who decided in favor of the city pre-trial, granted what's called summary judgment, saying, listen, there's no questions of fact. There's only legal questions, so we can deal with it without a trial. And we have two captains, I believe, and they filed a suit claiming that 2 years prior, they engaged in protected activity of a vote of no confidence, and that 2 years later now, they are being retaliated against because the deputy chief requirements and process is all being changed. And the court holds two important points. The first one we see as a common theme, which is gap in time between what you say you did and when they retaliated. And there are a ton of cases on this. I've raised it a number of times, so kudos for the defense lawyer. But it's just saying, look, 2 years goes by, and even a year. I have cases 6 months, right, depending on what it is. But that's the retaliation, the act you claim you're being retaliated for is too far in the past for us to create a causal connection between what you did and what they're doing. also on kind of a McDonnell Douglas shifting burden, even though that wasn't here, they said, listen, the city came forward with a reasonable explanation about the process, which, by the way, used external evaluators who had no knowledge of what happened 2 years ago. At least that's what they said, right? And why wouldn't you believe them? And so there's a point to be made here. But in any event, the judge says, okay, one, too remote in time, and two, the city came forward with a good reason why they changed this process and are doing things this way, and it has nothing to do with you, right? And so that's really the important thing. Just because somebody does something doesn't mean it's because of you. It may affect you negatively. That may be a benefit in the municipality's mind, but that's not why they're doing it. So I guess a couple of points. One is, if you want to retaliate against somebody, wait 2 years and then get back at them. So it does create a hurdle that's tough. And two, maybe you should look at why the municipality, who you say is grieving you, is doing what they're doing. If they have a reason for what they're doing, and three, which I loved, is external people used in the promotional process. I think that was a great move. Right? Because how do you say they had knowledge of anything or they're personally involved? They don't. They're just external. I thought that was a great move for them. So it's a great case to highlight. If you're going to make a change, don't worry about somebody in the past.
Yeah, I think their stronger case would have been if they even then it's tough to allege retaliation. I'm looking at the battalion chiefs and the pay cut for future battalion chiefs. These guys were captains, so their next bump up is a battalion chief spot.
And you said last week, people may not want to take it.
Well, that's the issue. And but how do you allege retaliation when it's a negotiated agreement?
Right.
It may very well have been this for that. It may have been retaliation in reality, but it's negotiated, and that meant the union conceded, or an arbitrator ordered, but either way. So I think that sort of undercut them as well.
Yeah,
it's not that they weren't retaliated against. Maybe they were, but just for everyone's knowledge, there are a series of lawsuits out of Manhattan Beach. I know at least two I've got in the database, and from some of the readings, I think there's been some others. So yeah, there's been some
same allegations.
Yeah, similar issues, labor management problems there. So little hotbed, and we see these little hotbeds of litigation pop up from time to time. So
that is definitely true. That's definitely true. Okay, so this one is where this is just disgusting, and obviously we like coming to providers' defenses, but not when they're this person. So we have an appellate court in Maryland. I have some issues on this, but has upheld the dismissal of criminal charges against an Annapolis firefighter. People may remember this because we covered it. She was accused of filing a false special incident report. So I don't totally, this part is interesting. And then we have another one coming up, which is just like this, but
very similar. And that's
very similar. Yeah. So I almost was thinking it was that one for a second. So this one is the question of the statute of limitations for a misdemeanor in all but very few cases is 1 year. So here we had criminal charges, a misdemeanor, right? 1 year or less in prison. And they filed after the 1 year, but prior to 2 years. The statute allows a 2-year statute of limitations if the misdemeanor is created by a public officer. Well, here we have a paramedic who was not deemed to be a public officer. There was a 4-part test, I think, the court goes through and says, yeah, some are in your favor, but you don't take an oath of office, which is scary because they probably did take an oath.
Most firefighters do take an oath of office.
Right, that's what I thought was weird. They probably did. But the other factors, right, they really didn't line up to being a public officer. And I agree, a paramedic is not a public officer. They can't act on behalf of the municipality, right, with sovereign immunity and such. So they the court correctly dismissed this case. The facts were unimportant. It's the question of whether the misdemeanor could be brought in, less than 2 years or not. So that was good. But some people do escape criminal charges based on statutes. of
Yeah, well,
limitation,
we've
time
talked
limits.
about the reason why we have statute of limitations and if they could go back and charge you with a misdemeanor going back 20 years. I mean, how do you defend yourself? Who are the witnesses? Where's the documentation? Yeah,
Right.
so
Unless you're in New
20
York or
years.
California and you're a sexual predator 80 years
Yeah,
ago,
right,
then
right. And
where they allow you
then
to be sued.
yeah, and that's a politically correct solution, which creates a set of nightmares for other people.
Right.
So you're trying to take care of one problem on the one end, and you create this nightmare on the other end. Um, but my point, roughly 5 years ago, I'm trying to think of exactly when, about 5 years ago, I realized that we were having a problem, and the fact pattern, they're almost like cookie cutter incidents where we respond with police. Um, the patient ends up either passing away or suffering grievous injury. Okay. And there's a lawsuit. Typically, these suits often went just against the police, either under the Eighth Amendment or um, due process violations or Monell type Fourth Amendment unreasonable search and unnecessary roughness. No,
Yeah.
uh, but the point being that we have always seen a lot of lawsuits under 1983 alleging a
Yes.
constitutional violation against police officers when someone passes away that's just been apprehended or someone experienced a mental break. About 5 years ago, we started seeing more and more of medics and firefighters being included in the sort of breadth of what happened. And we were there all along. We were there in the background, but I think what has caused the attention is the body cam.
Yeah.
And so what happens is in virtually any big city, there are attorneys who specialize in these 1983 actions. And typically they will get every single body cam at the incident scene. If there's 30 police officers, they're going through 30 dash cams, 30 body cams. It's a laborious process. But in the terms of going through that and they're looking at it, they're looking at the police reports and trying to look for inconsistencies. They stumbled upon a reality that medics are saying they are, doing an assessment of a patient and nobody got within 10 feet of
Right.
the patient.
Well, and
And
we're going
nobody
to
got a
get to that
refusal
next.
and no, right. And so on and so forth. So what we're seeing, and you see, this is how it happens with me. I read it and say, oh, that's interesting. Okay. And then another couple of weeks, I see a cookie cutter of the same case. I'm like, wait a minute. Right. And then
Right.
I see another one and another one. And so you almost wonder whether or not attorneys at continuing legal ed classes or maybe bar association committee meetings are discussing this fact. And flip over to the fire department side, we know the medics are under a lot of scrutiny from their medical director about their reports. And it's really easy for a medical director to just strictly go on what's in the report. Your report is lousy. You didn't do this. You didn't do that. Fix your report to the point where the medics say, all right, to make the medical director happy, I got to check this box, check that, got to do all this stuff, but they're not doing it.
Yep.
They're not
Yep.
doing it. They're saying they're doing it. Well, that works fine until you have somebody pass away. And we shouldn't be. I'm not,
No.
running cover for them, but they're doing it. And then you have this scenario and where, the report does not reflect what was actually done. And I've got a couple of dozen cases that are cookie cutters here. We just happen to be talking about two of them this week, but
Yeah, and I think the advice, listen, if you screw up on a scene, own it because bearing it or trying to avoid it, one, probably brings you into the criminal arena, falsifying public documents, lying to medic, right, withholding critical whatever, but your career's over. Better to make a mistake and go through some sort of remediation or own up, but that's not personal to you. I mean, yeah, you made a mistake, it injured or killed somebody, right? But you own up to it. You try to hide it or cover it up or act like it didn't happen, you've just crossed yourself from a civil issue or getting
but I've
fired to
done it.
going to
I've done
jail.
it this way 1,000 times, and it's never been a problem.
Right. Right.
So
Yeah.
the flip side of this is I believe medical directors ought to be required to ride EMS units at least once a month or quarterly or whatever, so that they understand the pressures that are happening at the scene. And I know docs are very proficient in handling pressure in an emergency room where they have all this
Right.
infrastructure to support them and nurses and technicians and all that. Get in the field, understand what the medics are going through, and work with them so that we can make it reasonable, make the reporting requirements reasonable. You can't expect people to do things that are unreasonable. They'll say they did it, but they're not going to do it.
Right. And well, and the other problem with medical directors is they're spread so thin, at least in my area in upstate New York. I mean, they're just spread so thin. They take on, they're all very good, but they're overwhelmed and they take on like 10 ambulance services. You can't competently be a full-time ER or whatever doc and also serve 5, 10, 15 ambulance companies in any way that's going to do anybody justice. You're a
Yeah,
name on a paper.
and my point, they don't necessarily have to ride in every one of them, but they gotta
Right.
get in the field.
They got to understand it.
They've got to be at the scene where you've got this out of control person who's potentially violent, potentially is going to run out into traffic. You can't get close to him. You can't do an assessment. So stop telling your medics you have to do an assessment.
Right.
And that way they're not going to be lying on their report just to keep you happy.
Yeah, but here's the other thing. Like, so, we're going to get into this last case with the Iowa and the injection error, which was one of a billion errors on this, right? But, you can do an assessment. I have this case now in with the FDNY where I'm defending two EMTs in the FDNY, and they stood away from someone. I'm not going to say much more, but they stood within 2 feet, 3 feet. They grabbed his pulse, right? But other than that, they looked at him. They can evaluate breathing, circulation, color, diaphoresis, speaking ability, clarity, watching their mouth move, right? I mean, there's a lot of things we can do by not touching the patient. So
Just don't say you did more than you did.
exactly. Document I evaluated breathing, right? And respirations and color and skin temp or
Patient
whatever you
appeared to
did,
be
you did.
breathing. He was standing upright, screaming.
Right. Right. Presented a danger to myself and others. And then we have Iowa.
All right.
So
Yeah, this is
this is the one. So I apologize in the last one. If you were the person involved, I was not talking about you. I was actually talking about this person, which is a horrible scenario. So here it begins, and there's a lot of coverage, and we could spend 20 minutes just going through the facts as you've just berated them, which is perfect. But and people should read the facts to see. Everyone's a don't do this, don't do this, don't do this. But to your point, now we have a situation where and I'm going to shrink the facts down to the problem. But we have a situation where police arrive. They've got an out of control patient, maybe, or somebody who's believed to be a harm to themselves, right? The officers are there. Finally, the paramedics arrive. They call for assistance. They encounter a patient who's, appears to be confused, disoriented while speaking. That's an evaluation, right? to your point. The officer is attempting to move the individual, but he's fighting, right? And he's being combative. So the officer says, look, which I think is a great response. Maybe there's something medical going on as opposed to I'm just going to tackle you, handcuff you, and throw you in jail. He says, maybe there's something medical going on. So kudos to the officer, right? Unfortunately now we get the paramedic. And it's funny, I read this. I had to read the allegations in the lawsuit because the point is they've already been charged with manslaughter. Now we have a civil suit, which always follows or predates. But the civil suit quotes things that were said. And I'm like, yeah, we say that all the time. What's wrong with that? Right? So I'm going to quote some of those. But what people have to realize is what we hear is not what the public hears. What we see is not what the public sees, right? So, the paramedic says, what kind of drugs you got on board? And then the complaint says, well, she asked that question from several feet away and failed to do any assessment. Wait a minute. That is exactly an assessment, right? Did you take any drugs? That is exactly an assessment. So to me, this lawyer went a little overboard on the complaint. Doesn't mean they're going to lose, and then they said, are you schizophrenic? Are you supposed to be taking any meds? Reasonable questions with somebody who's acting this way. And then she said she did an ALS assessment. Now, I'm not going to comment yes or no because I don't know what the protocol here is for what constitutes an ALS assessment. Usually it involves, some leads and taking some
Well,
vitals.
but we always, when I'm teaching classes on report writing, I always say, don't write conclusory,
Right.
write
Facts.
facts.
Yep.
Okay. An ALS assessment, I completed an ALS assessment is a conclusion. Let's
Right.
talk about the facts. What specifically did you do factually,
Yep.
granularly?
Yep. And then here's when this gets bad because I have no problem what happened, right? They're evaluating from a couple of feet away. I'm not approaching a patient or a person who the police just called me for, right? Unless it's like a stab or a gunshot or something. But you got a patient who's potentially violent and the police are concerned enough to have 8, I think there were 8 officers at one point here, right? So this is, they're concerned. So of course the paramedics are not just going to walk up and grab them. In any event, at some point after a lot of back and forth and I'm forgetting how they're going to characterize it, what's unquestioned, I believe, or will be proven, is that the paramedic then gives a dose of what she thought was going to calm him down, but instead gives him a paralytic, which is usually used to intubate somebody. So instead of giving like a ketamine or something, right, that she thought she was giving, she gives a paralytic that we in the field call socks. But
I talked to my son Andrew about it because when we first covered this, I think we might have talked
we
about
did.
it and Andrew, for those of you who aren't familiar, he's a trauma surgeon now in Columbus, Ohio. He works for Ohio State, but he was a firefighter before he went to med school. And he said when I gave him the facts, he goes, "Oh my God." He said, I mean, if you properly maintain it, he uses zirconium all the time, but he said that that person is going to be fully conscious
And they
and
were.
and not able to move or breathe. They will not,
Correct.
but they're going to be totally conscious when this is happening. They're going to be
Yeah.
fully aware that they can't breathe and they can't move.
And let's stop here. You've got a patient experiencing exactly what you're talking about, saying, am I going to die? Help, I can't breathe, all these things, right? And at this point, the paramedic had a choice between going to prison and not. Being right, saying, "Oh my God, what did I just give? I can't believe I made that error." That's like, okay, you're getting sued, but you're probably not going to prison, right? Here, it's a string of lies after another. False documentation, not telling the
Well, at least according
hospital,
to
not
the allegations.
what's it?
At least according to the
According to
allegations.
the
Yeah,
allegations. But
yeah.
the manslaughter
Let's.
charge we've already covered. Those were the allegations in the
Those were the
manslaughter charge.
allegations. Yeah, I don't believe she's pled or the case has been heard.
No,
So
I think this is still
yeah,
pending from
yeah.
what I tried to Google it. So
Mhm,
so in any event, the paramedic allegedly, right,
mhm.
after giving the wrong drug, doesn't document, doesn't tell the hospital, doesn't correct it, and apparently knew. Right. So the question is, at what point, to me, if I'm the defense counsel and I don't do criminal law, but you'd be saying, at what point did they know such that they should have done all these things? Right. If they didn't know, yeah, it could be negligence, certainly, but maybe it's not gross negligence, or maybe it's not recklessness,
Right.
right? I mean, so everyone should realize, like, the city, or doesn't automatically lose the lawsuit just because you gave the wrong drug. If if the standard is you didn't even attempt to be careful, gross negligence, not the lower standard of you screwed up, you didn't act like an ordinary EMT or paramedic, that could make the difference. If the person said, well, I checked the vial, I thought it was right, it was the same color, it was put in the wrong place, not my fault, whatever, I tried to be careful, but I wasn't. Okay, that's negligent, but maybe not gross negligence, and you don't necessarily lose. Here, the allegations are that covered it all up.
Yeah.
So at that point, you're done, right? Because you never told anybody.
That's a conscious decision. She made
Right.
at least the allegations are that she made a conscious decision not to inform the others on the scene and then not to inform the hospital. Now, she did inform the hospital once she got to the hospital, but she
Not
didn't
en
alert
route.
the hospital. So that's where I think there's a factual question about, was it en route to the hospital that she discovered it, or was it truly before she even departed the scene, she
Right.
was aware of it? So
And with bad documentation, you're it. when you don't document your screw ups, it looks like you're intentionally trying to hide them. And
Well,
that's what she's
my
looking
son
at.
in medical school said that that was one of the things that they taught them, that when you make a mistake, you own it. You own it. You tell the patient. He's a surgeon, so if the person makes it, as soon as they're capable of understanding, after post-op, you meet with them and you tell them, this is what happened, and if they don't make it, you do the same thing to their family.
Right.
And which is, by the way, the exact opposite of what they teach us in law school to do. Okay.
Right.
But there's actually some science behind it that results in fewer lawsuits, and when there are lawsuits, lower judgments.
Yep.
And
there, somebody asked me, it's funny because I'm using this case. I was going to use the other one, but now we have another part of it. But I'm using this case. So I'm teaching down here where I am in Florida, and I'm going to be teaching some chief officers and line officers with our friend John Murphy. And this is one of the cases I'm using is don't ever tell anyone to fail to document anything. I've had instances where I got a call and they said, I requested my union rep before I write a certain report. I said, well, what type of report? They said, well, a medical report, like a care report. I said, you shouldn't do that. You've got to write the report. There's a requirement. It's like, well, I'm concerned how I write it. I said, you write it truthfully and factually, as you said. I said, I said, if you have a report due to the hospital, you can't delay it. You have an order to complete, and they did. They had a 4-hour order to turn around the charts. And I'm like, you can't delay that just because you screwed up. You've got to document what you did. Don't hide it. So that was my advice. And
cover up is always worse than the initial crime.
Yeah. And it makes it look like it's not a mistake. And even so, even if it was originally a mistake that you then covered up, one, it makes it look like it was carelessness. Two, you look like a liar. But three, here's the biggest problem, which we have here. If there's a point you could have stopped the harm from continuing, at that point, your mistake is now intent.
Right. Exactly.
Right. Okay. I mean, that changes the whole ball game. You could have stopped this if you just admitted your mistake. So to everybody listening, to all the officers, own up and fix it. Lessen the harm, mitigate the damages is what we'd say in law, but lessen the harm and then own it. We all made mistakes. Find me somebody who hasn't made a mistake. We've all made mistakes. I could probably write a book on my mistakes in 30 years. I mean, if you haven't made a mistake, you haven't tried. Yeah, right. Past the statute of limitations. In any event, okay. Well, I think that is all of them for Memorial Day we got.
I think it is. Yeah. Let me just make sure. Yeah, that's it. So, all right, Brad. Well, thank you again. And next week, I am traveling to Lee Summit, Missouri. So I'm gonna be on the road on Monday. So we'll have to figure something out. But
we will figure it out as always.
Maybe a little bit later, probably maybe 3:00. We should be able to get it done. So, but
our viewers will be waiting on pins and needles.
There we go. All right. Well, that'll do it for another edition of Fire Law Roundup. We'll see everyone next week.